Hi guys, and welcome to part 3 on the law on security and credit transactions. Today we'll be talking about the contract of guarantee as well as the contract of suretyship. Okay? Now please remember, this is only for educational or informative purposes and is not a substitute for proper legal advice or for studying and understanding the law. Please do not forget to hit the subscribe button. Okay? Now, what is a contract of guarantee? According to the law, it is one where a person known as the guarantor binds himself to the creditor to fulfill the obligation of a principal debtor in case the principal debtor fails to satisfy that obligation. Okay? So it is an accessory contract, meaning it cannot exist without a principal obligation. The principal obligation may be a loan, no? That is the most common example. So in case the principal debtor fails to pay that loan, the guarantor answers for it. Okay? Now, as an accessory contract, the contract of guarantee may also be constituted to answer for voidable or unenforceable contracts, and it even may exist to guarantee a natural obligation. Okay? Next, we have the characteristic that a guarantee is a subsidiary relationship. Okay? In other words, the guarantor will only be liable after the principal debtor is found to be liable. The contract of guarantee takes effect only when the principal debtor fails to satisfy the obligation. Okay? So what are the consequences of this subsidiary relationship? Okay? First, while this contract of guarantee may cover future debts, okay, such as in a continuing guarantee, no claim may be had against the guarantor until the debt is ascertained, okay, it is clear what amount is due, and unless the principal debtor is already liable on the debt, okay, until the debt is demandable. Okay? Now, a guarantee may also be constituted to answer for a conditional obligation. In other words, an obligation which is subject to a condition. Okay? But the guarantor will only be liable after the condition happens. Why? Because in cases of suspensive or resolutory conditions, the efficacy of the obligation is either suspended or resolved upon the happening of the condition upon which the obligation depends. Okay? Now, another rule on the nature of subsidiary nature of the guarantee. Okay? The guarantor may bind himself for less, okay, but not more than what is due from the principal debtor. Okay? In other words, if the debt of the principal debtor is 500,000 pesos, the guarantor may bind himself to answer only for 400,000 pesos. But the guarantor cannot bind himself for 600 pesos because it is higher than the principal obligation. Okay? Remember, this guarantee is only a subsidiary contract. Okay? And the nature of liability of the guarantor is only subsidiary. Okay? Now, in case the guarantor binds himself for more than the principal obligation, then the amount will be reduced until the limits of the principal obligation itself. Now, other characteristics of the contract of guarantee, no? A contract of guarantee is unilateral, meaning there is only an obligation on the part of the guarantor. Okay? There is no obligation on the part of the creditor. Next, a contract of guarantee is generally gratuitous. However, it may be onerous if the parties so stipulate. Okay? Now, what else should we know? No? In a contract of guarantee, this is a consensual contract, meaning it is perfected by the mere agreement of the parties. It is also an express contract, meaning that a guarantee can never be presumed to exist. Okay? It must be proven by the express agreement of the parties. Okay? It is likewise strictly interpreted, meaning that the liability of the guarantor will only be limited to the four corners of the document. Okay? Now, if what has been stipulated is a definite liability on the part of the guarantor, then the guarantor will only be liable for that definite part which has been agreed upon, which is usually only the principal obligation. However, if the stipulation of the parties is for an indefinite liability of the guarantor, then he may be liable not only for the principal obligation, but for all other amounts which have to be paid, such as interests or even judicial costs, provided there has already been a judicial demand or he has been judicially required to pay. Okay? Now, a guarantee may be entered into with or without the consent of the debtor. And the rules on payment and performance will apply here, specifically 1236 and 1237. In case a guarantee is entered into without the knowledge or consent of the debtor and the guarantor pays, he will only be entitled to reimbursement insofar as the debtor has been benefited. He is likewise not entitled to subrogation. Okay? However, if the guarantee is with the knowledge of the debtor, then the guarantor is entitled to the right of reimbursement and subrogation. We'll discuss that more later on, no? The effect of payment by the guarantor. But for now, let's move on to the qualifications of a guarantor. The law lists several qualifications of guarantor. However, these are set for the benefit of the creditor. So the creditor may waive these requirements and say that, okay, you can be the guarantor of my debtor. Okay? However, in the absence of the waiver of the creditor, the qualifications of the guarantor are as follows. First, he must be a person of integrity. Second, he must have capacity to bind himself. Third, he must have sufficient property to answer for the debt. Okay? Third, next, he must be subject to the jurisdiction of the court where the obligation is to be complied with. Okay? So these requirements or requisites or qualifications of the guarantor must be present only at the perfection. In other words, they may be lost after the contract of guarantee has been perfected, no? Now, there is an implication here, no? In case he loses the qualifications, that is all right, the contract of guarantee still exists. The implication is the guarantor will still be liable even if he becomes insolvent. Okay? Except in the following instances. Now, what happens is, in case the guarantor either becomes convicted of a crime involving dishonesty or he becomes insolvent, then the creditor may demand another guarantor with the requirements I mentioned earlier, yung integrity, capacity, etc. Why? Because the guarantor has lost his qualifications by virtue of becoming insolvent or by being convicted of a crime involving dishonesty. Okay? So the creditor has the right to demand a new guarantor that has those qualifications. However, that exception is also subject to an exception. In the following cases, the creditor cannot demand a new guarantor if the creditor had required or stipulated that a certain person, yung tao lang na yon, can be the guarantor. Okay? In that case, the creditor cannot demand a new guarantor. Why? He's already stopped. He has agreed that only that person can be the guarantor of the obligation. Okay? Now, let's go to a very, very important characteristic of the contract of guarantee. No? In a contract of guarantee, the guarantor is entitled to certain rights. In particular, there are two very important rights which are the common questions in any law exam, no? When it comes to guarantee. We have the benefit of excusation and we have the benefit of division. Okay? These come into play when the guarantor is sought to be held liable or is being asked to pay na on behalf of the debtor. Because remember, the purpose of a guarantee is that the guarantor answers for the debt of the debtor when the debtor cannot pay. Okay? But before the guarantor may be asked to pay, he can invoke either the benefit of excussion or the benefit of the division, or both. Okay? They are not mutually exclusive. He can invoke both. Now, let's first talk about the benefit of excussion. What is this benefit of excussion? It is otherwise known as the benefit of exhaustion. Okay? In other words, it is a right by virtue of which the guarantor cannot be compelled to pay the creditor unless the creditor has exhausted all of the properties and all of the legal remedies against the principal debtor. Okay? In other words, let's say the scenario is like this. The debt of the principal debtor is now due and demandable. Okay? The creditor makes a demand on the principal debtor to pay, but the principal debtor does not pay. Okay? So the creditor now goes to the guarantor and says, now, since you are subsidiarily bound, please pay for the debt due by the debtor. The guarantor can refuse to pay by saying, hey, the debtor has all other properties. Okay? Please go against them first before you go against me. Okay? The duty of the guarantor is to point out all available and remaining properties to the creditor belonging to the debtor in order for the creditor to go against those first before he goes against the guarantor. Okay? Now, it may so happen that a case may be filed by the guarantor, by the creditor against the debtor. Okay? In that case, the guarantor is also entitled to notice, no? To be notified of that case so that he can appear and participate. And if he so appears, he may still invoke the benefit of excussion. Okay? So the rule is a demand by the creditor upon the guarantor entitles the guarantor to the benefit of excussion. How is it exercised? By pointing out the remaining properties of the debtor to be satisfied by the to satisfy the debt to the creditor before the guarantor may be held liable. Now, what if the guarantor has pointed out all remaining properties and the creditor either intentionally or negligently fails to attach those properties or satisfy the obligation out of those properties? Then it is the creditor who will suffer the loss, because properties have already been offered to the creditor and he did not take advantage of them to satisfy the obligation. Now, the creditor suffers the loss to the extent of the value of those properties which he did not take advantage of. Okay? Okay. Now, there are certain instances when the guarantor cannot claim the benefit of excussion. Now, what are these? The law provides certain instances. First, of course, if the guarantor expressly renounces that right. He says, I don't want this right. Okay, you can hold me liable now. The guarantor is free to do that. Okay? Next, when the guarantor has bound himself solidarily. Okay? Because in this instance, he assumes a direct liability as a surety. We'll talk about surety later on. But in this case, if the guarantor bound himself solidarily, he now assumes direct liability and he does not enjoy the benefit of excussion. Next instance when no excussion is allowed, it is when the principal debtor is either insolvent or has absconded. He has run away, from the country and can no longer be found. Next instance when excussion is not available, when execution upon the properties will presumably, just presumably not satisfy the obligation. In other words, it's not enough. Next, if a pledge or mortgage has been given as a special security. Why is the benefit of excussion not available in that case? Because the creditor can simply go against the pledge or mortgage directly. There is no more need to exercise the benefit of excussion. And finally, we have where the guarantor fails to invoke the benefit of excusation as a defense. Okay? Because defenses may be waived. Okay? In case of failure of the guarantor to invoke said benefit or right, then he loses it. Okay? Now we can move on to the right of division. Okay? Now let's say the principal debtor has a debt owing to a creditor. In order to answer for the debt, instead of just getting one guarantor, the principal debtor gets several. Okay? So let's say A, B, C, D, E. There are five guarantors. In case the guarantor will be held, one of those guarantors will be held liable, the guarantor who pays has the right to seek contribution or reimbursement from his co-guarantors to the extent of their proportionate liability. In other words, the benefit of division is simply an instance where there are several guarantors and there is only one debt, and there is only one debtor rather for the same debt. Okay? And in that case, the obligation will be divided equally among all the guarantors. Okay? So in other words, the liability of those co-guarantors is joint. Okay? And in a joint liability, each guarantor is only liable for his proportionate share in the obligation. The exception is where it has been stipulated that their liability shall be solidary. Okay? And in case they bond themselves solidarily, the benefit of excusation will no longer take place. Why? Simply because in a solidary obligation, payment by one extinguishes the obligation, subject to the right of the payer to seek a reimbursement from his co-guarantors. Okay? Okay, let's move on now to the rules in case a guarantor has paid on behalf of the debtor. Okay? There are several scenarios here. Let's begin with the general rule. Okay? If the guarantor has paid on time after the debt is due and demandable. Okay? Now, assuming all the rights have been invoked and payment of the debt by the guarantor is proper, what are the rights of the guarantor? I mentioned this earlier, but if the guarantee was constituted with the knowledge and consent of the debtor, then the guarantor is entitled to two remedies: indemnification and subrogation. Subrogation, we discussed this already, okay? Please refer to my other video. But in subrogation, just a reminder, in subrogation, the person subrogated to the rights gets all the rights of the creditors, all the rights and remedies and rights of action against the debtor. In other words, the guarantor who pays now stands in the place of the creditor who has received payment and may now go against the principal debtor for all the rights and remedies. What I want to talk about more in detail is the indemnification or reimbursement as a remedy of the guarantor who has paid. Okay, what does this indemnity comprise? Okay, it includes the total amount of the debt, of course, no, the principal obligation. But the guarantor may also claim legal interest from the time payment was made known to the debtor. Okay, this legal interest is different from any interest that the creditor may have gained. Okay, this interest is now by reason of the payment of the guarantor. And once the guarantor makes the debtor know that he has paid on behalf of the debtor, the guarantor is entitled to legal interest from that moment that the debtor has knowledge of payment by the guarantor. Okay? Next, what if it is without the knowledge or consent of the debtor? I mentioned earlier that the guarantor can only get reimbursement only up to the extent by which the debtor was benefited, and there is no right of subrogation by the guarantor to the rights of the creditor. Okay? Let's go to the second scenario. In the second scenario, there is payment without notice to the principal debtor. Okay? In other words, the guarantor should notify the debtor first before he pays. Okay? So, in this case, where the guarantor did not notify the principal debtor, then the principal debtor may set up defenses which could have been set up against the creditor at the time of payment. Such as the best example is the obligation had been extinguished by payment or whatever other modes of obligation. Okay? In other words, the guarantor should not have paid because of the whatever defense the debtor will raise. Okay? That is if the payment was without knowledge of the debtor. Let's go to the next instance. What if the guarantor paid before the debt was due or demandable, or before it had matured? Now he has to wait for the period that is constituted to expire. Okay, because the debt is not yet due and demandable. They must respect the period. Okay? Unless, of course, the debtor has either consented or ratified the payment. In this case, the debtor subsequently gains knowledge. Okay, either through his consent or ratification. And in that case, the guarantor can now claim reimbursement. Okay? Now, what if there is repeat payment? In other words, this scenario contemplates the debtor having paid, okay, and the guarantor making a repeat payment, or vice versa. Okay? What is the rule in this case? As I said, the general rule is before the guarantor pays, he must notify the principal debtor. Why? Precisely to avoid these scenarios, no, that there is a repeat payment or that there is payment before maturity, etc. No, notice must be given. Okay. Now, if notice is not given, the rule is the guarantor can only claim what he has wrongfully paid, no, from the creditor. We apply the principles on solution indebity, no? Okay, or payment by mistake. Since the debtor had previously paid, the guarantor does not go after the debtor, but rather the creditor. Because the creditor is the one who has received payment twice. Okay? That's why the guarantor can ask the creditor to please return what you have received by mistake. Otherwise, you shall be liable for unjust enrichment for having received payment twice. Okay? Okay, now let's go to another rule. In case there is a compromise entered into between the creditor and the guarantor, this will benefit the principal debtor but will not prejudice him. The vice versa is also correct. Okay? What if a compromise is entered into between the creditor and the principal debtor? The guarantor will not be prejudiced, but if it is beneficial to him, he will benefit also from that compromise. Okay? Now let's move on to to another special rule on guarantee. Okay? Generally, until the principal debtor has paid the obligation, the guarantor has no cause of action against the debtor. Because remember, the guarantor is only subsidiarily liable, and he will be liable only in case the principal debtor cannot pay. Okay? Now, until the guarantor has paid on behalf of that principal debtor, there is no reason to ask the principal debtor for reimbursement or any other thing, no? So the guarantor has no cause of action against the principal debtor until the guarantor has paid the creditor. Okay? Now, there are exceptions. Okay? What if the guarantor has been sued for payment by the creditor? Since he's already being sued, he can now ask the debtor to please pay the creditor. Or, in case the guarantor pays, please pay me now. Okay? Another exception is when the principal debtor is now insolvent. Okay? Another exception. What if the principal debtor had bound himself to relieve or release the guarantor within a certain period of time, and that period has expired? Then in that case, the guarantor has a cause of action against the principal debtor to release him from the liability on the guarantee. Okay? Next, when the debt is due and demandable. Since the debt is due and demandable, the debtor now has the obligation to pay or to satisfy said obligation. So the guarantor now has a cause of action against the debtor to go pay it in order for the guarantor to avoid any liability. Okay? Next, in case there is no period set for maturity, there is no due date, then 10 years, because that is the prescriptive period on a contract. Okay? If 10 years has passed, then the guarantor has a cause of action against the principal debtor to be released from the obligation of guarantee. Okay? Next, if there is an imminent danger of the debtor becoming insolvent, because in that case, the guarantor is likewise exposing himself to liability. Okay? So what are the remedies in those exceptions? As I mentioned earlier, the guarantor can either ask release from the guarantee from the debtor, not the creditor. The guarantor will ask to be released from the guarantee from the debtor, or his alternative remedy is to ask for a security which will protect against proceedings or suits by the creditor against him, or the danger of the insolvency of the debtor. Okay? Again, the remedy is either ask for release or to ask for a security. Okay? Now, let's talk about this special relationship called a double or sub-guarantee. What is a double or sub-guarantee? Simply, it is a guarantee by, it is a guarantee of a guarantor, no? So, there is an additional person. So, let's say there is a creditor and a debtor, and there is an obligation between them. There is another person known as the guarantor who answers for the failure of the debtor to satisfy the obligation. And that guarantor has a sub-guarantor. Okay? So, that is the sub-guarantee. A guarantor who guarantees the performance of the guarantor. Okay? What are the rules in this case? First, if there are several guarantors here involved, no? The main guarantors are several main guarantors. The liability of the sub-guarantor is the same to each of the co-guarantors as the liability for which he bound himself with the original guarantor. Okay? He will answer for the liability of this guarantor and all other guarantors. Okay? In the same terms for which he bound himself to the principal, to his own guarantor. Okay? The sub-guarantor also enjoys the benefit of excusation not only against his guarantor but also against the principal debtor. Okay? So he can invoke the benefit of excusation by pointing out the remaining properties of the debtor before he can be held liable. Okay? Now we can finally move on to extinguishment of the contract of guarantee. Okay? Now, a contract of guarantee may be extinguished for the same causes for extinguishment of obligations. I have a 7-part series on my channel. You can check that out, no? We have payment, performance, etc. Okay? Now, there are additional grounds to extinguish the contract of guarantee, no? We have a situation first where the creditor voluntarily accepts property, whether real or personal, from the guarantor, no? And in that case, the guarantee is extinguished, no? The acceptance by the creditor of the real or personal property must be voluntary, and it must be for the purpose of extinguishing the principal obligation. In that case, the contract of guarantee is extinguished. Next, in case the debtor has several guarantors, the release of one of those, any one of those, will benefit the others. Okay? Meaning, the contract of guarantee is extinguished all across the board. All other guarantors are likewise released. Okay? Another instance when the contract of guarantee is extinguished, okay, is when there is an extension granted to the principal debtor. Okay? This extension of the principal debtor is more onerous to the guarantor, especially where he did not give his consent. And in that case, the contract of guarantee will also be extinguished. Now, this extension is not a mere delay in making a demand. Huh? Okay? There must be an express extension made. Okay? And this extension does not contemplate, as I said earlier, a mere demand, but covers a situation where prescription has set in. In case prescription has set in, then the contract of guarantee may likewise be extinguished. Okay? Finally, the last instance where a contract of guarantee will be extinguished is where, through the acts of the creditor, the guarantor cannot be subrogated to the rights of the creditor. In other words, by the own acts of the creditor, he has impaired the right to subrogation of the guarantor. And in that case, the contract of guarantee is extinguished. Now, we can move on to suretyship. What is suretyship? No? Suretyship is similar only to guarantee, but there are marked differences. Okay? They are similar in the sense that they are both accessory contracts. In other words, they cannot exist without a principal obligation. They are also unilateral, consensual, and express. Okay? Meaning that there must be agreement, and the agreement must be expressly stated. Okay? However, the difference lies in the nature of liability of the surety. In the earlier discussion on guarantee, the guarantor is only subsidiarily bound. In other words, he is only liable when the debtor fails to pay. The guarantor is also entitled to the benefit of excusation. The guarantor is also entitled to the benefit of division. Okay? This is not the case in a suretyship. Okay? Because the nature of liability of the surety is direct. Okay? A surety binds himself solidarily with the principal debtor, but this is not a solidary relationship as in the law on solidary obligations. Meaning to say that the surety is not a principal debtor. He is not a co-debtor. He is simply a surety who has bound himself solidarily. In other words, what is the effect? Okay? In case the creditor asks the debtor to pay, even without the debtor saying, wait, I cannot pay, the creditor can go straight to the surety to ask for payment, because the liability of the surety is direct. Okay? So in that case, the creditor may proceed directly against the surety for satisfaction of the obligation. Okay, so what is the difference between guarantee and suretyship? Okay, in guarantee, there is an independent agreement where the guarantor undertakes to pay in case the debtor cannot pay. Okay, that's the key word, cannot pay. Whereas in a surety agreement, the surety assumes liability as a regular party who answers to pay the debt of the debtor if the debtor does not pay. The difference again, guarantee, guarantor answers if the debtor cannot pay, and in surety, the surety answers if the debtor does not pay. Okay? Now, the contract of guarantee involves a collateral undertaking. Okay? Whereas a surety involves an original liability on the part of the surety. He is an original party who promises to answer for the liability of the debtor. A guarantor is primarily liable, whereas the surety is only the guarantor is secondarily liable, whereas the surety is primarily liable. Okay? In other words, the guarantor is secondarily liable because he can only be held liable after demand and the properties have been exhausted on the part of the debtor. Whereas the surety is primarily liable because he answers for the debt in case the debtor does not pay. Okay? Now, the guarantor is an insurer of the solvency of the debtor. This just means that the guarantor warrants na the debtor will be able to pay, and if he cannot, I will be the one to pay. While a surety, he insures the debt. Okay? Meaning to say, even if the debtor has sufficient property with which to pay, I will still pay if you make a demand on me, because I promise to answer for the payment of that debt. Okay? Now, another difference is in a contract of guarantee, notice is required. Okay? In several instances, there must be notice that a demand was made on the debtor to pay. There must be notice that there is a case filed for collection against the debtor. That is the rule in guarantee because this is a subsidiary undertaking. Whereas in surety, there is no need for the notice requirement. Why? Because the liability of the surety is primary and direct. Okay, he is presumed to know the default of the principal debtor. Okay? So, that's it for the discussion on guarantee and suretyship. I hope you have picked up the salient points of this law, no? This is only the tip of the iceberg because there are a lot of other principles involved, but these are the basics that you need to know. Okay? If you take away anything from this vlog, please just remember that in a contract of guarantee, a guarantor promises to pay if the debtor cannot pay, while in a suretyship, the surety promises to pay if the debtor does not pay. Okay? So that's it for part 3. I hope to see you again in part 4. Bye!